you, Mr. Chairman. Professor Henderson, I get the sense that there's a little bit of a disagreement on the panel, that Professor Jackson and Coffey have a different idea of what the standard should be for liability, and I think that the distinction pivots on this personal benefit versus indirect benefit standard. So I wonder if you have a response to the arguments that they have made as to why you, if I remember correctly, do not believe the indirect benefit standard should be the appropriate standard, but also what would be the adverse effect if that were to become law?
Thank you, Senator. I have a lot of agreement with what they've said about cyber hacking and great respect, and I agree. I think the focus, as Professor Coffey said, should be on stealing. Professor Jackson said the SEC knows wrongfulness when it sees it. I am skeptical of that. The most famous insider trading case probably ever was SEC versus Dirks, where the SEC's view was that Mr. Dirks, who was trading on information revealed to him by an insider at a company that was running a giant Ponzi scheme, was wrongful, and they wanted to punish Mr. Dirks. Taking information from a company that's running a Ponzi scheme that they had tried to tell the government on repeated occasions was a Ponzi scheme and nobody would listen, and trading on that information to move the stock price in the right direction, that's not wrongful conduct. It might be stealing from the standpoint of the company whose property has the information, but it's not wrongful in any sense. The SEC, frankly, their attitude for the last 5 decades has been to try to create a parity of information between traders, that people should trade based on the same information. And if that's the view of the commission and their idea of wrongfulness, I think that's a real problem. I think the idea that what Professor Coffey said, which is if someone steals information in return for some financial gain, and it doesn't have to be a bag of money, as Professor Jackson said, it could be a favor you're doing for someone knowing you're going to get something in return, something that you're doing this to serve your own selfish interests. That's a problem. That's just like stealing office furniture. We don't allow people to do that. If what you're doing is really not about serving your own personal interest, it's about revealing fraud within a company, then I think that's a completely different situation. This idea that we're going to have a property rights approach where the companies get to determine what the property is, I think is the wrong way to go. I think we should focus on the stealing, and I think we should say when people have motives to steal that are personal, self-serving, you don't need a bag of money. The government does have to show the burden, but if they can show the networks that Professor Coffey's talking about of information trading and groups of people in these activities, then I think that should be enough.
Thank you. Mr. Burton, we've had several observations about the huge decline in the number of public companies in America, despite the fact that we have more people, we have more businesses, we have a bigger economy, yet we have fewer publicly traded companies. Just briefly, what do you think the main reason is we have fewer public companies in America today than we did decades ago?
I think there are two related reasons. One is a massive increase in the regulatory burden of being a public company that's been ongoing for approximately 3 decades, and then is about to get radically worse if the SEC promulgates some of the rules that is recently proposed. The second reason is a substantial increase in litigation risk and the costs associated with either preemptively protecting yourself against that litigation or defending against litigation.
Could we go, with respect to the SEC's new raft of disclosure requirements, it's my understanding that for the first time the SEC is going to require the disclosure about facts that are not financially material to the companies that have this burden. That strikes me as a whole new layer approach to regulation. I wonder if you have any thoughts on the wisdom of that.
Well, I think going down that path is a serious mistake, but they're in effect trying to redefine the way materiality has been understood for 8 decades. And the proposed greenhouse gas emission rule or climate change disclosure rule that was released about 2 weeks ago would literally triple the cost of being a public company. And that's going to have dramatic effects. It will make the going private transactions associated with Sarbanes-Oxley's internal control reporting requirements look like child's play. And then there are also, if you look at the OMB Unified Regulatory Agenda, there's a whole series of other similar type disclosure requirements in the pipeline relating to DEI or human capital management and so on down the line, which have either no relationship to the financial outcome of the company or a tangential relationship to the outcome of the company.
And that's a complete departure from the historical norm on the terms of the standard.
It is, and I think ultimately it may well, I know it will seriously undermine securities laws because it's at variance with its fundamental historical purposes of helping to provide material information to investors so our capital markets are more efficient and so that investors can make more informed investment decisions.
Thank you. Senator Menendez?
Thank you. Well, let me thank the chairman for holding this hearing. I also want to thank my colleague, Senator Reed, who's at the Armed Services Committee, for his tireless work to pursue